He is a head at PFC, TIFAC, Government of India, New Delhi. Dr. Rashmi Sharma, ma'am, Scientist E at the SEED, SSTP, and NCSTC Division, DST, Government of India. And also to Miss Kiran Sharma, ma'am, Examiner of Copyright at Delhi. And very warm welcome to our participant to this last day of Gujarat IP Festival. So yesterday we have seen very brief information about the GI by Shri Chinnarajan Naidu sir and Shri R.D. Barhat sir. So we also have Dr. Narottam Sahu sir with us. So I welcome you, sir. Sahu sir. Sir, it's muted.
Dr.
Yes,
Sahu,
sir.
you're muted.
Yeah,
Yes.
So, good afternoon to everybody. Respected Dr. Yashwant Dev Panwar sir, Head Patent Facilitation Center, TIFAC, Government of India, New Delhi, and Dr. Rashmi Sharma Madam, Scientist E, Seed Division, State S&T Council Program, and NCSTC Program Division, DST, Government of India, Madam Kiran Sharma, the Office of the Copyright, DPIIT, Government of India, all our faculties, all our professors in the state S&T Council, the university IPR cell, all our guest faculties of previous sessions, the community science center coordinators, science communicators, grassroots innovators, and our colleagues from Gujarat National Law University, our patent information center with Center of Excellency. Today on the auspicious day of Ganesh Chaturthi, and also the concluding day of our 6 days Gujarat IP Festival, which was we are conducting on virtual mode. It is going to be concluded with a great message that how this IP would be going to be our day-to-day life activities and a day-to-day life business. So with this objective, we have started this program on 17th of August. That time we were a little bit afraid that it may or may not be appreciated by participants, because everybody knows that IP is a very hardcore subject, very abstract topic, and it is the only the talk, and it is the only the function of hardcore researchers and engineers and technocrats who can go and well with the designs and the techniques. But once the sessions was going on, and we have all presentations by our eminent experts as well as the participations interaction, we are now sure that it is whatever the aim that was planned during the conceptualization of this program, it is coming to a practice that yes, we can have this IP culture in our home, in our office, in our workplace, in our market, in our society. So that's the reason this message with a new activity, new initiatives, and a new normal situation, we will definitely contribute to Honorable Prime Minister's message that Atmanirbhar Bharat, and we can be that much of, we can say that we can take that much of proud for our local thing, which for which we should be vocal. So with these two message, this program started, and I think on this concluding day, 6th day of the program, we have an overwhelming response. About 1,800 participants all the 6 days, on an average of 100-150 per day. And all the sessions are also very well gelled with the normal life, daily life activities, so that how many parts or how many designs that is available in a mobile or a cycle or a motor car type of these things. With this type of background, the session started and concluded with a great message that yes, IP should be our culture. So with this message, I welcome our faculties and our eminent guests of this concluding day. We have Yashwant Panwar sir, who is with the head of the Patent Facilitation Center of TIPAC, and is a great mentor for this IP initiative by the Government of India. He was associated with the State S&T Council since the program initiated, and in fact, we can say that he is the founder member for this conceptualizing this IP cells with the State S&T Council, and since then he is coordinating, he is mentoring, and he is orienting all the PIC's faculties as well as the new faculties with this thing. And he's a very good faculty and very good well-wisher for our GUJCOST activities. So on behalf of GUJCOST, our DST Government of Gujarat, I welcome to you, sir. And I hope that your support and your contribution will be motivate our faculties as well as our students in the state in general. Today we have Dr. Rashmi Sharma, madam. She is a very dynamic officer in the Department of Science and Technology, scientist and innovator also, and a policymaker also, who is also looking after the seed division, which is talking about all these entrepreneurships as well as the new technologies with a specific target audience, with our science state S&T Council programs, STTP, as well as the NCSTC, for which the communication is also the mandate, that how best the science communication can go to the grassroots level. So with these three portfolios and three divisions initiative, Rashmi ma'am is doing a great job at SSTP headquarters and DST Government of India. And I am happy that Rashmi ma'am is here today to have an interaction with our faculties as well as our professors, those who are in the university IP cells, and the participants and innovators. So on behalf of GUJCOST and our Department of Science and Technology, Government of Gujarat, I welcome you, ma'am. We think that your contribution will be giving a new dimension, new direction to these activities. We have Kiran Sharma, madam, who is the patent copyright examiner at the DP IIT, Government of India. She is also helping us, and the copyright topic would be new for our participant today. I hope that your presentation will be very beneficial to all of us. On behalf of GUJCOST, DST, Government of Gujarat, this IP Festival, and our PIC cell. So I once again welcome all our guest faculties here, and I also welcome all the participants. And with this Ganpati Utsav, Ganesh Chaturthi, the God of knowledge, we can conclude this festival with a new beginning, new hope, and a new spirit, you can say. So once again, I welcome all our guest faculties. I hope together we can definitely have a great role in the national call, that is Atmanirbhar Bharat, as well as being vocal for the local. Thank you all.
Yes, sir. Thank you for your kind words, sir. Today we have topics of discussions that what are the IP facilitations available by various organizations in India, and we'll also see the registration process of copyright and how IP will connect to Atmanirbhar Bharat. So I would like to hand over the session to Yashwant Dev Panwar, sir. Yes, sir.
Thank you, Mrs. Wala. Ms.
Yes, sir.
Wala, I think somebody else has already.
Yeah.
Yeah, so you have to just remove
presentation.
that.
Dear participant, please turn off your microphone and cameras, and please do not click on presentation mode. Just sir, one person.
Okay.
Yeah.
No, it's okay.
It's
Okay.
yeah.
And I believe about 40 odd people are sitting in lobby. So can you let them in? Because
Yes.
yeah, out
Sir,
of
they are all in. They are all in, sir. 50
Yeah.
participants are there. They are all in.
Okay,
Yes.
okay. So thank you, Satya and Vala, for creating this opportunity to speak with the scientist from Gujarat. And let me also extend my warm welcome to all the participants. And before I proceed and start talking on my topic, I would like to thank Dr. Narottam Sahu for his nice word and organizing this program and creating opportunities for all uh, people to learn intellectual property rights. And I believe this learning is always two-way process. So we impart knowledge, we discuss our mind with others, and at the same time, during the question answer, we learn a lot. So I also would like to thank Dr. Rasmi from DST. So I think she is working hard and sitting in office now on this festival day also. So that shows her commitment to the cause of science and technology. And now she is going to take lead in the area of intellectual property rights also. So we are hoping a lot of positive progress with regard to IP facilitation, IP creation, IP protection, and IP utilization in days to come. So once again, uh, I think, voila, I'm missing Hiranmai. He will join little later, or he is not there.
No, sir. He has some work, so he can't connect.
Okay.
Yeah.
So whatever time we have lost, we can use his time and distribute amongst
Yes,
us.
yes, sir, you can.
Okay. So I'm going to start my presentation now. Uh, I'm going to share window. So you are able to see?
Yes, yes, sir. Just you have to just zoom out if. Uh,
Is it okay now?
yes, yes, sir.
Okay, so thank you for all good words, and I thank once again to all the participants for joining this session. And I don't think I need to go into very basics of intellectual property rights now. But first of all, once again, I should extend my heartiest congratulations and wishes for the Ganesh Chaturthi. But at the same time, I hope you would be able to see. So I think keep your mask on because I'm sitting at home, so I really take advantage of not putting mask on. So save yourself, save others too, and happy Ganesh Chaturthi, and facilitate people from being away from COVID. At the same time, let us facilitate intellectual property rights also. And let's see how we can use intellectual property rights also for mitigating effect of COVID to some extent. Uh, so I think once again, I would like to emphasize that when you go in public, put on mask, keep the social distancing, and we have all gone through these phases of lockdown one, then lockdown two, and lockdown three, and lockdown 4.0, and then we were waiting for five, but again came in unlock 1.0, 2.0, and now at the moment we are running into unlock 3.0. So I would like to draw the parallel from this mechanism or process we have gone through to the area of intellectual property rights also. So I would like to say that we have been working hard for many years to teach people to really lock their intellectual property rights or protect their intellectual property rights. But let's look at unlocking intellectual property rights also, not only protecting, but utilization of intellectual property rights also very, very important. So whatever facilitation mechanism exists in the country, barring one or two, all are focusing on protecting intellectual property rights. So let's widen the horizon of ours and use intellectual property rights. At the same time, we also have to pay adequate attention to protect intellectual property rights. And I would like to tell you about this Arogya Setu app. And at this time of pandemic in unlock 3.0, or what we may talk about uh, the phase where we are going to openly contest and face the challenges posed by COVID and try to handle through this app, which is called Aragvi Setu, and I would request everybody to download and use this app. And the purpose of showing this is not only to advise you to use and save yourself and save others, but I would like to really mention here that while making such an app, a lot of IP has been unlocked. And at the same time, unlocking intellectual property rights, a lot of IP have also been created. So that IP was locked down and now it's being unlocked and is being used by the society at large. So the unlocking process has been done by people who prepared this app in very record time, which uses many technologies. So it has copyright of various frames, designs, the source code, uh, and how it looks. It can be design registration possible, and if at the moment still we are waiting for feature phone Arogya Setu app, I'm not sure because I have not followed up for many days. So if we are able to have Arogya Setu app for feature phone also, not only for the smartphone, so that will have very many new technological intervention. And if those interventions are new, and then those also can be patented, protected. Uh, so this is at each stage of our functioning, IP is very, very important. Only question is to identify what we have done is protectable or not. And if something is protected, can we make use of that protected thing with the permission, without the permission, with the royalty, without the royalty? Those are the aspects we can look little later. But the identification of a potential use is very, very important. Uh, Before I go in the facilitation mechanism, I would like to take a couple of conceptual things. Today is a festival, Ganesh Chaturthi, so and very many things happening, and then the Puja festival is coming, Bengalis, and then Dasara and Diwali, and all those things are ahead of us now. If we get into festive season, I think we should enjoy the festivity of intellectual property rights also. Uh, we all know, let's look into Ramayana time when Lakshman Murcha happened. तो किसी को पता नहीं था कि how this can be treated. Then Susen Vaidya from Lanka at that point of time was invited to look at his ailment. उन्होंने देखा तो कहा कि इसे तो संजीवनी बूटी की जरूरत है, तो कौन लाएगा, कहाँ से लाएगा, वो सब हुआ. He recovered after taking the sanjeevani. I'll not go into the other part of the story, but here what point I would like to emphasize, that the intellectual property protection was there at the time of Ramayana also. If we look at Mahabharata time, how Eklavya learned the archery, धनुर्विद्या उन्होंने गुरु द्रोणाचार्य से कैसे सीखी, और आखिर में गुरु द्रोणाचार्य उस राज्यसभा में एक जज का सम्मान रखते थे, ओहदा रखते थे. तो उन्होंने कहा भाई एकलव्य से कि तुमने मेरी बौद्धिक संपदा या इंटेलेक्चुअल प्रॉपर्टी राइट्स की चोरी की है. यू स्टोलन माय इंटेलेक्चुअल प्रॉपर्टी राइट्स बिकॉज यू लर्न द आर्चरी विदाउट माय परमिशन. सो you have stolen my intellectual property rights, so you have to pay penalty. And who decide this. Nowadays, court judges decide this, that you have to pay penalty and stop producing. So after removing thumb, Eclavier was no longer allowed to practice that archery because he cannot do it without thumb. So in the modern system, we say injunction granted by the court. So that was the process of granting injunction in the case of IP violation. So the Ramayana time, Mahabharata time, and as a human being, we always have tendency to protect our intellectual property rights. Let's not go to Ramayana per se, but go to our childhood days. Childhood days, when we were writing very specific notes for our examination purpose, we would not have shared with best of our friends. We would have shared general notes, teachers' notes, but the very specific notes prepared by us for getting ahead of others in those exams, we have never shared. So that is the human instinct where we would like to protect intellectual property rights. And tragedy occurs when we don't have system of protecting intellectual property rights. Then what we tend to do, we tend to not to disclose those creation to other, and those creations would die. It's natural death. And it is well said that nothing dies faster than ideas. So if you, very many people have very many idea, but this very instinct of a protection is not safeguarded by the government or a system, then these ideas will die their own death. So if we really need to nurture those ideas, we have to provide it protection. And very good example of this, after Sanjeevni, this scientist from TBGRI in Trivandrum, and in the very southern part of the country, in late 80s or early 90s, roaming into to the forest area or a tribal area, they noticed one thing, that the tribal people used to extract uh, some thing from leaves of few herbs. So that particular extract they used to drink in the evening after whole day's work. And the scientists observed that after having that extract, those people were feeling quite energetic again, and they were able to do away with whole day's tiredness by drinking a small portion of the extract from that particular herb. But the problem was that extract was supposed to be taken immediately, or in a very short span of time after the extraction process. So scientists from TBGRI, with this observation, work on that extract and came up with uh, convalescent or a syrup. They named it Jeevani. There's a trademark they have given. So this is a IP. They patented the process of keeping that extract useful for longer time, or keeping it a shelf life little longer. They have evolved a process. So they patented that process. They protected the trademark, and when they licensed this particular product, they shared the benefit of a royalty coming out of this patent, or a benefit of this patent, with the tribal people. And so they plowed back uh, those benefits money. Later on, this got into some kind of other issue. So same way, from Sanjeevni to Jeevni, and then if we look at Corona cures, a lot of hit and trial hydroxychloroquine sulfate was tried around the globe, and remdesivir was tried, the various vaccines were tried, and the process of looking into those vaccines was through patent documentation. People examined patent documents with regard to vaccines which were treating other ailment, and as per genome of this coronavirus, they found that this combination of HIV and one of the other ailment uh, or infection, this dengue and all. So they found and worked on patent data and analyzed which all vaccines are used for those ailments and what kind of combination can really work against this. So this provides the technical information to look into those problems. At the same time, there were other efforts of Ayush ministry having kadas, and I'm not with tea. I'm also having a long to keep my throat clean. So, so this again a symbolization, the intellectual. This side particularly a symbolization, and we are talking about Sanjeevni, Jeevni, and after this Sanjeevni, Jeevni, and very important solution, Government of India with the initiative of Prime Minister is e-Sanjeevni. Now, to Sanjeevni to Jeevni, we have reached to e-Sanjeevni, where we are using technology for telemedicine and treatment with the for COVID and other ailments through e-Sanjeevni. So that is how the selection of a word e-Sanjeevni can play a very good trademark, or if it is protected and used. So with this particular background, let us see what is a patent. This has been explained to you by various speakers, but I would like to explain in my own way to emphasize and tell you the important role of a facilitator. So why this becomes a facilitator role is very, very important. So what is patent? Patent is a deal between government and the applicant. So who can be applicant? Inventor himself can be applicant. If he's employed with some employer, so depends on the employment contract whether he can be a patentee or the employee would be patentee only. So that depends on that. Uh, if there's an organization, there's a industry, there's a government department, so all depends what is their rights and charter and what are the different agreements. Accordingly, ownership of intellectual property rights can be decided, and in particularly patent, applicant is the owner of a patent document. So if inventor themselves are an applicant, then they are the owner of a patent. Otherwise, inventor's name appears in a patent document as an inventors. So what these applicants do, they have to submit complete technical description of their invention along with a fee to the government. And who is the government? In this case, the patent office. So they have to submit the complete technical description along with the uh, drawing sheets, etc., to the patent office. And in return, government gives exclusive right, means government gives a monopoly rights to those applicants for excluding others from using that patented item or technology for the period of 20 years. For the period of 20 years. So let us, before go into the facilitators thing, let's look at the whole chain of the processing of a patent application. And I would like to tell you documentation at each point is very, very important. First and foremost is inventor and applicant. So the sprouting start from inventor and applicant to really go for patenting. So that seed uh, has to be nurtured by the facilitator. And what are the role of a facilitator? I will talk later part of my talk. So, what inventor or applicant can interact with a facilitator? And finally, those IP attorneys are supposed to draft patent application. See, I have seen n number of applications, patent application, filed directly by inventors, filed directly by some applicants. But when we look, if they are thorough professional and they have experience, well and good. But most of the time, these inventors and applicants have no prior experience or adequate acumen to really draft patent application appropriately. So a lot of patents they filed, in some cases patents have been granted also, but when question comes of enforcement of those patents, it's not at all possible because the language used in the claims of a patent is so general and generic, and that has been tamed by examiner and a controller to a very narrow claim finally, and it becomes a piece of paper only or a publication only. There is no way we can protect. And I think most of the patents filed by amateur professionals finally ending into no protection. So people can feel happy that I have filed patent, it has been granted, but that patent may not be enforceable in most of the circumstances, barring few, where there are understanding with users of the technology and then users are big companies, then there's a possibility. So role of facilitator is very important in identifying inventions, then deriving the scope of a protection, and also oversee attorneys in appropriately drafting and having appropriate scope of protection in those claims. So this is a very important bridge between patent attorney and inventors, because most of the time what happens if this facilitator is not there, uh, it is actually does the role of a translator also, in addition to providing financial and other assistance. Because in a scientist language, many cases attorney may not understand attorney language, scientists may not understand. And most of the time, my experience is when we send the final drafted patent application and ask inventors to evaluate the claims, they say, this is what I have invented. I am unable to make it that this is what I have invented. So that's where the role of facilitator becomes once again very important. So this uh, invention go through these two filtration process. The first level of a filtration, like we have in AquaGuards, is a facilitator. He examines various issues relating to that inventions, including uh, ownership rights, inventorship rights, scope of invention, whether it's a process or a product, identification of scope of a protection, looking into the novelty aspects and other features which can be really nurtured in that particular invention, and in some cases it can suggest further experimentation and the generation of a data for adequate protection of patent claims. Then it is referred to attorney to put whole this raw material which has been prepared jointly by inventors and the facilitators into the form of a patent document, and finally patent is filed. But this is not the end of the story. Once patent is filed with the patent office, examiners and controllers together will raise very many objections. Few of them would be formal and others would be technical in nature. So again, one cycle of iteration will happen between attorney, facilitator, inventor. So that's a two-way process. It goes to examiner through facilitator attorney, comes back through attorney facilitator inventor, goes back to examiners through the same route. So this is back and forth. Sometime goes once, some kind goes twice, sometime it goes thrice, and may finally end up with hearing with the examiner by attorney, and then that discussion also the inventors and facilitator roles becomes very important to provide right kind of argument to the objections raised by examiners. So finally, through this chain and a documentation process which is done at each level, finally granted patent becomes a reality. But challenge doesn't end there. Actual challenge starts from there, where to make commercial use of that patents after a grant is a real challenge we are facing. And most of the time our scientists feel that it is one patent, one invention can lead to commercial exploitation or a commercial product. That is not truth. If we look at devices, gadgets, things around us, they are covered by few thousands of patents. If I look at a mobile phone, this my smartphone is covered by more than 2.5 lakhs patent claims. If I calculate roughly around maybe 8 to 10,000 patents, it is covered. So if one patent, if I think I can commercialize, uh, it can happen in chemistry or a pharmaceutical where you have a new molecule and it becomes a new drug lead to treat maybe COVID, then one patent can lead to one product and you can have a commercialization. But in complex technology world, it is not possible always to have one patent. So I think this is the area where facilitator again has to look into and help inventors and applicant for commercialization and putting those inventions for the public use, maybe through various business models where everybody can have their pie of benefit from uh, which is accrued by the commercialization of those inventions at a large scale within the country, outside the country. Uh, so what I have vaguely discussed all these issues, role of a role of a facilitator, sorry, not facilitation or a facilitators. So there are an intellectual contributions. So when those write-up comes, inventor discussed finding real technical problem which was solved, identification of that, because inventor will come with other mindset. He will say, I have made it. It is coming from outside in 10,000 US dollar. I made it in 100 US dollar. The same thing. Now, what is the technical problem have been solved to really make it cheaper? That has to be identified. So it is not that you have been able to make it in $100 in place of $10,000. Uh, that is not an invention. So what is the real technical problem? Whether the raw material which is being used is changed and adapting to this new raw material which is cheaper into the process, which has some problem. It could not have been taken just like that. If that is solved, then that becomes a technical solution to the real problem. So that is the first and foremost role of a facilitator. That's identification of real solution of a technical problem. A and B is very important. After doing that, uh, facilitator has to distillate ideas behind the solution, because they have to argue and ask inventor that what was the idea behind doing this, how you did it, because those will actually help you in appropriately putting your different embodiment in your patent document or a complete specification. So that is another role of facilitator, to distillate ideas behind the technical solution. Then once these three steps are done, then they have to compare and assess patentability with existing solutions available in patent documents as well as in other technical journals, books, internet, even on social media or whatever the source is. Comparing existing solutions with uh, like the same way which I just shared a picture of a mask in the form of Ganesh, if it's designed registered of some article. So this first shared in the social media, that can also be a source of destroying novelty of your invention. Then envisaging whether it's a product, a process, the improvement thereof, and its allied uses. So facilitator has to look into those and provide legal support in the form of attorney, which we are doing from TIFAC with the support of Department of Science and Technology. And I think Rasmiji is taking a lead into that now. I think support is very, very essential. We can work, but the financial support and policy support from government is always desired and required to move ahead in this area. So legal support we garner through the panel of patent attorneys, and then funding, who pay for it. Uh, so I'll not go into these specific details of applicant published ever or examination of this through different. So here the role of facilitator is actually tapping the unleashing mind of scientists, which is unleashing in the form of enablement of invention. So the good patent is maximizing the scope of the protection. But in the quest of maximizing, if you make that a generalized statement, you can lose. It is like uh, the rubber, if you stretch beyond a point, it breaks. So that particular kind of balance is essential for a good patent, which is now should be easy to defend. If you want to have that, then the clarity of concept in claim is required. Clarity in the scope of claim is required, and claims are always fully supported with description. That is required. Uh, it should be possible, easy to detect use. So title is suggestive of a use. If that is there while drafting patent specification, that's where facilitator always have to keep an open eye when the attorney does work on invention. So it should be easily detectable by other people. Then it should be easy to prove infringement. See, value of patent or IPR is not on protecting intellectual property or patent. Its real value is in enforcing intellectual property rights. So if you cannot prove the infringement, you cannot enforce. So that facilitator has to take care of this particular aspect. So I'll not go into this particular slide because I have already crossed my allotted time for 40 minutes by 1 minute calculating. So I'll go with the example of various organizations which facilitates filing and protection of intellectual property rights and patents. Oldest organization in this is National Research and Development Corporation, which is under Ministry of Science and Technology. Same our sister Department of Scientific and Industrial Research, DSIR, and it is an public sector enterprise PSU. Uh, the role of this NRDC is to commercialize technology or a technology transfer from government R&D institutions and laboratories and take it to the industry. And in the process, they have a scheme of facilitation of filing of a patent. They support government R&D institutes, they support academic institutions, and even they support individual innovators. But their annual capacity of support is ranging between uh, uh, 40 to 80 patents a year. What the money and amount they have in the kitty at the moment. So they can, I believe, at the moment can support 100 patents max in a year with all considering all capacity of a human resource they have, the money they have, or facilities they have. They also support filing of a patent abroad, patent in other country, but that is available for selected patents where they see real commercial value outside the country. And in that case, patent is not filed in the name of an actual applicant. They have to assign the rights in that invention, the title of the invention to National Research and Development Corporation, and has to part with an expenditure in filing patent in other country. So you lose the title as an applicant, it goes to NRDC. And if you want to commercialize your technology through NRDC, then they charge 30% of a benefit accrued in the form of royalty or one-time sale amount, 30% taken by NRDC and 70% goes to applicant. But to initiate that process, one applicant has to transfer the title. The transferring title mean transfer the ownership rights in patent to National Research and Development Corporation. Uh, Another very new initiative by the government of India, the CPAM. So they also have a mechanism of facilitation of filing patents, and they don't discriminate uh, with anybody. Not only they are supporting to government R&D institute, academic institutions, individuals, even they are supporting to industry. Uh, they're not even differentiating between large and small industries, but their mechanism is little different than us because they provide money. So you can look into the scheme of CPAM for taking support. Uh, but this is a new system, and again, the interest and effectiveness of this program and the part of there's facilitation mechanism is rooted through patent offices. For startups, they have a scheme called startup facilitation. And because CPAM and patent office is under the same ministry, Department of Internal Industry and Internal Trade, DPIIT, Department of Promotion of Industry and Internal Trade. Earlier it was DIPP. Uh, so what is happening in this case, CPAM, they have actually tied up with the patent office to request all patent agents in the country who can offer their services to startups as in facilitators for filing, drafting and filing, prosecuting patent application on behalf of startups. So if those patent agent agrees to register as a facilitator and patent, if they file patent for startup, so for a startup there is a fee reduction of 80%. So only 20% fees has to be paid by startup. So if the total expenditure initially comes for patent filing comes around, let's say 40,000. So for a startup, it would be max 10,000. So the only filing fees in place of 8,000, it's a 1,600 for startups. So very less fee for startups. And this facilitators charges are borne by patent office. So patent office will pay this facilitator who has registered. The registered patent agent has again registered as a IP facilitator. So there are 400 IP facilitators have registered with the patent office. So if these facilitators file patent on behalf of a startup, patent office pays 15,000 rupees at the time of filing of patent and 10,000 rupees at the time of a grant of a patent. Or I think I'm just mixing. It's maybe other way around. Uh, so that expenditure is borne by patent office. So the startup has to pay only 20% fees. The same facility has been extended to industry and other organizations by CPAM, but the effectiveness is to be seen in totality. Uh, So that's another facilitation mechanism which is available. Then National Innovation Foundation. They do scouting of innovation throughout the country through various modes, exhibitions, and then padyatras, zodhyatras, meeting grassroots people, taking them onto different forums. So but they help grassroots innovators in filing patents, and they have internal mechanism of drafting and filing patents. So they scout those innovation, they distillate them and convert them into the patent document and file with the patent office and finally convert into the granted patents. So this is NIF is a body of Department of Science and Technology, and fortunately, this is actually hosted in Gujarat with IIM Ahmedabad. So you have this facility for grassroots innovator. They serve the whole country. Then another scheme, I think, Ministry of Small and Medium Enterprises. I think Dr. Satish would have already spoken to you, but I can give few features of the scheme. They have a mechanism of establishing IP facilitation centers for small and medium industry, and those centers are established as the universities. Those centers are established at the colleges. Those centers are established at uh, different government department in the states and even with the industry bodies like CII, FICCI, etc. And their budget is now, I think, enhanced to 1 crore rupees per year, and for 3 years for this IP facilitation centers, where they provide manpower support, they provide separately for workshops and training, even international trainings, and but they don't have a patent facilitation mechanism directly because these IP facilitation centers can guide them or put through some system, but the expenditure to be borne by the small industries in filing, prosecution, and handling patent activity of those inventions which they are protecting. So that is the mechanism, but in the same scheme, there's a mechanism of reimbursement of expenditure incurred by these small entities. So once patent is granted, if Indian patent is granted, irrespective of, I think earlier it was 25,000 and it has been revised, we can look into that particular amount. I'll just finish in 2-3 minutes. Uh, I just finished in 2-3 minutes. I think I've exceeded time by 7-8 minutes already, so I quickly finish it. So this MSME scheme through IPFC or without IPFC, if patent is filed in India, the flat reimbursement of 25,000 rupees, and if patent is filed in other country, you get a reimbursement of 2 lakhs of rupees after the grant. So it is after the grant, not before the grant. So initially, these small industries have to spend, and the claim happens after 4-5 years because grant of patent takes 3 to 4 years in India, and similar the time in other countries. Including filing a process, going through the process of international application or national phase. So the equal amount nowadays, if I look at it, for the same invention, by the time my European patent is granted or in a grant stage, my Indian patent is also granted. So it's a neck to neck. So we get reimbursement maybe after 3-4 years, and then the government process may take some time. So there need an improvement. But in other schemes like CPAM, NIF, NRDC, uh, they pay directly to attorneys, and in many cases, the government fees in like NRDC and us in NIF. There's another very important scheme with Ministry of Electronics and Information Technology, where ICT related inventions they support, and they also give a reimbursement. This is a very interesting scheme again. And the reimbursement, if you file patent application in other country, reimbursement is up to 15 lakhs of rupees. 15 lakhs of rupees uh, on production of actual data of expenditure. 15 lakhs of rupees, the max limit is there for one entity or an applicant, whether it's in a one country, two country, three country. And very interestingly, under this scheme, 50% is paid at the time of filing and 50% at the time of a granting. So it becomes a little better. When you are filing it, you immediately get reimbursement of 50% of the cost in filing other countries. So that scheme is very, very important. Another scheme, there are various schemes in the state governments. Like Karnataka government has a reimbursement scheme similar to MSME. Gujarat government has various schemes. They had a scheme through JITCO. I think Padmin Buch would have spoken to you regarding that scheme. So I'm missing Hiranmay. In education department, there is a scheme for reimbursement of 2.5 lakhs of rupees, a new education policy which was created by Gujarat government 2 years back. So student from schools, college, or higher education can get 2.5 lakhs rupees for prosecuting and handling patents from Gujarat government from education department. I think Hiranmay would have covered it better, but you can look into that particular scheme. Then I think Dr. Narottam Sahu and Satya, they also put up now some scheme in place where they facilitate likewise, in government of Rajasthan, government of Madhya Pradesh, West Bengal, Punjab, so many schemes in a state government, so people can look into those schemes. And over and all, now finally, I would like to talk facilitation mechanism of TIFAC and DST through different patent information centers, network of a patent information centers, and how this scheme of a Department of Science and Technology, which is implemented by TIFAC, is different from all other schemes. In this scheme of Department of Science and Technology, hand-holding is done from the beginning when the request is received, and we are doing away with all complex format business and puzzling formats uh, and different bottlenecks avoiding. We generally seek simple letter along with some write-up of invention. At initial stage, if inventors not comfortable to disclose all technical details, still we take those requests and examine them. And in the process of examination, we seek more details. But here, no other mechanism is uh, providing full assistance, and our focus is more on a technical and legal assistance and finance. All other schemes has attraction of a finance only, but our scheme has uh, complete patentability assessment done. And to let you know that our assessment went wrong in one or two patents where and those also can be discussed why that has happened. So patentability assessment is done in-house by PFC of a TIFA or our patent information centers at state councils like in Gujarat, Dr. Satya, Dr. Narottam Sahu, Ms. Wala and his team. Their team is doing patentability assessment and then sending it to us, and those patents are filed by drafted by professional patent attorneys on our panel. So we have a panel of all best firms in this country on our panel, and those patent applications are drafted. We give those requests to attorneys who has technical expertise in that particular area, of a technology. So, and the whole process of receiving request, examining patentability, then drafting patent application and a prosecution until grant is monitored by this network of patent facilitating center and patent information center, which is uh, running with the support of Department of Science and Technology. Uh, so at the moment, both PFC and PICs are directly supported by Department of Science and Technology financially, but the responsibility of a technical support to Patent Information Center has still been put on TIFAC, and we are able to work in this network and try to facilitate patent applications and other IP applications, and even patent filing in other countries also. And in some cases, we have facilitated technology transfer also, but not formally, informally, because it's not mandated in the charter of the Patent Facilitating Center of Department of Science and Technology. So these are the different facilitating mechanism around the government departments, center or states, and in center government, most of the department now have their own IP cells, like CSIR, DBT. They have their own IP cells, and they have again special purpose vehicles which are assisting them. DRDO has its own, DAE has its own. Initially, this PFC TIFAC used to handle patent applications for IITs, these DAE, DRDO whole portfolio was handled by us for limited period. Even ISRO we supported all, and now we help them in establishing independent patent facilitation mechanism within their department, and this model has been a success. And this model of Department of Science and Technology of patent facilitation was 3 years ahead of European model of facilitation mechanism of IPR help desk, which was established in 1998 for European entities. So we can feel proud of these initiatives and the impact of these initiatives, because when we started, 100% patent filing for academic institutions was done by us, and now it's 4%. We have enabled
Thank you, Yashwant sir. I think some network issue is there. It was very wonderful, informative session by Yashwant Dev Panwar sir. I think it's very, we are very much clear about all our doubts with the schemes and what are the facilitations are available by Government of India. Let's move to the next session by Dr. Rashmi Sharma ma'am. Rashmi ma'am. Yes ma'am, Rashmi ma'am.
Yeah, Jigisha, I'm just sharing my screen.
Okay, okay.
Yeah, good afternoon.
It's working.
It's fine.
Yes, yes.
So very exhaustive presentation by my colleague, Dr. Yashwant. And good afternoon, Namaste, Jai Hind to all participants and the team of GUJCOST. I would like to congratulate Dr. Narottam Sahu to organize this 1 week long IP festival. I think it takes a lot of courage, resources, and dedication to organize such an exhaustive event because IP itself, as Dr. Narottam Sahu has said, is a difficult subject, and to select the experts and topics and coordinate with the participants and experts is a huge task. So, congratulations once again to all the team members of GUJCOST, and I
Thank
would
you, ma'am.
like I would like to welcome all the participants because I'll come to the role of IP in our lives. As my colleague has already told you about how in the Corona we are looking into the IP also. Like he has told about the Arogya Setu app, and then he talked about the Sanjeevani and Jeevani also. So we all know that IP is in our life and embedded into our lives, and we are living in the world of patented products. If you talk about from a fountain pen's nib to a zip, which were invented in the early 20th centuries, and we cannot expect our lives to be without these small products or small parts like a nib or a zip. These products are used, like zip is used in your clothes also, in your bags also, so you cannot expect your life to be without these products. But these small things add value to your life, and these interventions are patented because it gives the right to the inventor to stop others from copying, manufacturing, selling without permission, thus adding to the economical benefits to the inventor. So that is the background. I'll say that as Dr. Sahu has said, that it is a very difficult area. Patent is a very technical area. So, but I'll say that these patents is not new terminology. It is not new. It started in 600 years back, when we have recorded the first patent, which was given to the Italian architect and designer in 1421 for his design of a boat which used to carry the marbles and construction material for a cathedral on the river Arno. So it gave all the rights to exclude all the new means of transport to this river, and thus he was the only person who was carrying the material to this for the construction. So it added the economical benefit to the inventor. Then came these are some of the examples, like why patents are important. So English patent of invention was granted in 1449 for the process of glass making, and which was unknown in the England at that point of time, and it definitely added the economical benefit to the inventor. So this is why a person should patent the knowledge and the invention which they are doing. The three landmark patents which happened in the 19th century was light bulb, internal combustion engine, and the telephone. Without these, our lives were incomplete, because if you can't imagine your life without a light bulb. And the entire automobile industry is based on this internal combustion engine, which was invented by Samuel Brown in 1823. Further was improved into a 4-stroke engine and then 2-stroke engine by Carl Benz, and was patented in 1873 or so. And that led to the foundation of the automobile industry. Similarly, the telephone, Graham Bell. So all the telecom industries has the foundation of this telephone invention, which happened in 1876. So whatever networking you are doing over the phone is because of the invention of this telephone, which happened in the 19th century. Then the most important invention which happened was the modern computer, which was patented in 1973, which was a electronic numerical integrator and computer. And this was the, if you see the right hand side, there's a picture of a room. This was basically a ENIAC, the electronic numerical integrator and computer, which was placed in 1500 square feet area. So that was the size of the computer at that point of time. And if you see now, people are taking the laptops, taking the palm tops and tabs. So the size has reduced. So as Dr. Yashwant has also said, that it is not that one invention will lead to the patent. It is over and above the invention happens, and then it can lead to another product also. So that is the protection of your IP is important. He has given a very good example that when we used to write our exams in our school days, so we used to share the general notes and the notes of the books, but whatever over and above we used to learn, we never used to share that. So that is true for all. So all the students, so when they want to keep themselves edge above the others, so they don't want to share their knowledge to the other students, fellow students. It is not that the patent had the patent culture was not known in India. It was known, very well known, and the first patent was granted to George Alfred Depenning in Calcutta for his invention of efficient pankha pulling machine in 1856. So it is now more than 150 years that India has known that the patents are granted for your intellectual property. So then the intervention of DST, what we have done as a part of Government of India, Department of Science and Technology, because science and technology plays a pivotal role in the socio-economic development of the country. So in this area, what the Department of Science and Technology has done, Dr. Yashwant has already briefed you about what are the initiatives the Government of India has taken in this direction. In the year 1995, when World Trade Organization was established, and there was a lot of hue and cry about the patent of neem, and the ecosystem of IPR was feeble. We had only 4 patents from 3 universities and 72 patent agents. We decided that we should formulate a patent facilitation center, and for that we used our autonomous institution, Technology Information Forecasting and Assessment Council, TIFAC. And we thought that it should be a single window platform to reach out to the universities and R&D institutions, so that it can provide support to them and create awareness among them about the IPR. So that the role has been done by PFC in the past 25 years. They have done wonderful job about creation of infrastructure and creation of knowledge about the IP. They have conducted more than 500 workshops and created awareness among more than 1 lakh students and faculty. And also we have established through this initiative patent information centers in 26 states, and the other agencies he has already talked about. So I'll focus more about the policy perspective rather than talking about the what are the mechanism and what are the facilitations we are giving. So Patent Information Center, I'll just give the brief of the Patent Information Center, because this is the latest data which has come out from the Patent Information Centers across the country, that in the last 1 year, they have done 500 IP awareness programs and workshops. They had filed 158 patents, established 100 IPR cells, and filed 14 geographical indicators, 1 plant variety also. So this is the outcome of Patent Information Center for the last 1 year, which is I think satisfying. But we want that it should be further strengthened so that they can take a more bigger role in creating the culture of IP protection in the states. So this is the global IP data. If you see that in 2017 and 18, we had received about the number of patent applications were about 31 lakhs. In 2018, it was 33 lakhs, which is a growth of about 5.2%, which is quite okay. And in other areas also there was growth seen for 15%, 5.7% in industrial design, and plant variety applications, 8.9% growth was seen. Now coming to the data for countries data. So top 10 countries, the China, if you see, has filed almost 46% of the patents worldwide. So, and if you compare the population of China and India, we are almost equal. And the patents filed by China and patents filed by India, if you compare it, it is very less. China has filed about 14 lakhs of patents, while India it is only about 46,000 or so. So this gap needs to be addressed. So we'll talk about this later. This is the data for scientific and research development organizations and the companies, Indian companies, the number of patents filed. So if you see, we have filed the top 10 scientific and research development organization. They have filed around 500 patents in 2017 and 18. And if CSIR institutions, which is about 38 institutions we have filed 176 patent applications. Now, this is the data for foreign resident applicants in India. So, top 10 foreign resident applicants. So, the total number in this series is like above 3,000, around 3,000. So, comparing the number of patents filed by the Indian scientific research organizations and the foreign resident applicants, it is a huge gap. And it is said that only 30% of the applications are filed by the Indian organizations, and rest of the 70% of the patents are filed by the foreign applicants. So this needs to be reversed and this needs to be addressed. This is the data for the IP, India, growth of IP in India. So if you see in terms of patent filing, we are almost stagnant, or you can say stable. But we have improved in the case of the trademarks and copyrights. So this is a good sign. And this is the state-wise data for applications filed by Indian applicants. We have, you can see that Maharashtra has filed almost 3,700 applications, and Madhya Pradesh has filed 190 applications. So if you see at the state to state level, there is a huge gap. So here we expect that the patent information centers of the state plays an important role so that these gaps can be addressed, and they can in fact create more facilitators, because as Dr. Yashwant has already talked about the role of facilitators. We have 400 facilitators as per the data he has given. So we need to create more and more facilitators and strengthen that ecosystem so that they can identify at a very nascent stage that what can be patented. So this gap needs to be addressed. And maybe we can take a partnership of the universities and other technical institutions, and we can rope these organizations to be partner with us. So each state can identify one 17 and 17-18 data. Some state has progressed, have showed improvement, like Delhi 1000 से 1400 हुआ है उसका पेटेंट फाइलिंग का. Then Bihar 26 से 63 हुआ है. Maharashtra is almost same, 3500 से 3700 हुआ है. Then Telangana 2000 से 2700 हुआ है. So it is like there is a improvement. We can see the improvement happening in 1 year of period. So this improvement should continue, and we should facilitate this improvement. These are the awareness initiatives in the country by different organizations. So total, this is the patent office data, and 114 awareness initiatives have happened in India from various organizations, and there are certain initiatives which has happened in schools also. 66 are there in Atal Tinkering Labs, including Atal Tinkering Labs. So law universities has also created certain awareness initiatives. I would like to show this slide because this is the initiative by US Patent Office. These are the initiatives. So they have very wonderful initiatives like IPs everywhere, and Meet the Team, where they have the participation of kids, teens, parents, and teachers. So, and then they are also taking care of the young inventors. So I think if we see this slide, it tells us about that we need to tap the potential of young inventors and school going children. So because that is an unutilized potential, we need to capture. Now, I would like to say that currently, these are the stakeholders, what we have in the patent filing. We have industry as a partner. Then we have R&D organizations, educational institutions, and the individuals. So, as a policy maker, we have the government of India and state governments. These are the policy makers. So, this is the system ecosystem which we need to strengthen further and see where are the gaps and how we can fulfill these gaps. So, if I evaluate these resources or evaluate my sources, then I see that there is a gap in this because if I see the data of educational institution also, there are only there are 10,000 technical institutions, and we have around 80 lakh students who are pursuing technical education in those 10,000 institutions. So where are the IPs? So only 2,000 to 3,000 IPs are generated from these institutions, and I was reading in the I think 2-3 days back only that only 95 to 97% of the educational institution, they are not generating any IP. So we need to cater to that gap area. So we have a more bigger role to play there. And now evaluating my sources or resources, I can say that we have to revisit our sources or resources. So while revisiting the sources and resources, the stakeholders which we are looking into are like the policy makers will be there definitely, and then I see that the schools also come pitch into the picture, and they have a bigger role to play because we have about 1.5 million schools in the country with 260 million students. So if we can nurture these students, school students, from the beginning itself about the invention, creation, and creativity. So that will be our pool, that will be our innovation pool. That because if you tell them in the beginning itself, at the young age itself, about how to do creativity and think innovatively and do more like designing aspects of that. So if that can be taught to the school going students and their teachers as well, so that they can take care of the needs of the students, so that can create a huge difference in the ecosystem. Because if I see that 1.5 million schools are there, if one school can generate one IP, so we can have how many IPs? So that is a potential area where we can tap into, chip into, and for that we need more and more facilitators. So or maybe we can create a model using universities as a guiding force, as a mentor, so that they can take or adopt a few schools in the states, and then they can further go ahead and creating this innovation ecosystem. So this is what I feel that it is very important. And for creating Atmanirbhar Bharat, this is important that because the PM's idea for creating Atmanirbhar Bharat is that we should be job creators rather than job seekers, and we have to have the comparative advantage in the sectors of agriculture, manufacturing, and services, and we should be actually looking into these sectors and gap areas, identify the gap areas in these sectors. So as my colleague has already talked about that hydroxychloroquine, when COVID came, there was a lot of information that this hydroxychloroquine cures COVID, and India was the 70% of the world supply was from India, but the raw material, the API, used to come from China and is coming from China. So that is the gap area. Like if we can develop certain processes, or maybe where you can take advantage of the monetary advantage or cost benefit analysis, or create a processes for generation of the raw material. So that could be the areas for creating Atmanirbhar Bharat, because Atmanirbhar Bharat is basically for creating sustainability for ourselves, and not and also for exporting purpose. So we need more and more ideas from the young generation, so that they can take up the creative thinking, and they should not be only mugging up the whatever is being taught to them in the classes, and they should be motivated towards creative thinking. If you see, like we are doing our meeting in Google, so there is no single platform. Like we have developed Arogya Setu app, but there is no single platform where we can conduct meetings. When the COVID started, we started using Zoom, and then because of the threat, security threat, the government has decided that we will not be using Zoom. So then we came to the other platforms like WebEx and Microsoft Team and Google Meet. So we were not having a single platform where we can do our webinars or meetings, online meetings. So that was the scenario. So it is not that we don't have the capability of doing that. It is basically we never thought about doing this kind of inventions, innovations, or creations. So we need to be a step ahead in taking this mission forward of Atmanirbhar Bharat, so that that ecosystem is developed, and our young generation will come forward for doing more and more inventions. So the awareness creation is one part, then facilitation is other part, and then obviously the role of mentors and guides comes, so that they are knowing each and every step of the process. So they are guided properly in this direction of how to protect their IP. I think that the MHRD ministry is also launching one scheme called National IP Awareness Initiative. So that is also a wonderful initiative, because if it can be awareness can be given to all the universities and colleges, so that will be great contribution towards getting them sensitized about what is their IP, what they are doing, whether it is patentable or not. So this is a step forward in right direction. But I feel that we should be as a state government partners, because without state help of the state governments, we will not be able to uh, do changes. So we want that PICs should take a lead in this direction and start creating more and more of facilitators. So with that, I'll like to thank the organizers, because I thought that I'll be talking about more of a policy intervention rather than talking about the how to file the patent or how to file a copyright, because that you have been listening to in past 5 days. So thank you very much.
Thank you so much, ma'am. It was very nice session and very informative, because more IP generation will leads to the our vision, that is Atmanirbhar Bharat. So we also have Yashwant Dev Parwar sir.
Yes, I'm
Yes,
back.
sir.
Sorry
Sir,
for
actually,
disconnection.
some technical issues were there, so I thought that
No issue, no
last
issue.
night
Good,
was
good.
were there. That's why I continued to the.
No, I think I have completed. I discussed with Satya. She said I
Yeah.
was at the end slide where I
Yes,
have
sir.
discussed facilitation mechanism of TIFAC, I believe.
Yeah. Yes, sir.
Yeah, so I think I'm done.
Yeah.
So I think I was listening to Dr. Rasmi. Congratulations and very nicely presented talk and whole background of IP for past years and future direction. Well laid. So we can jointly take questions, Dr. Rasmi.
Yeah, that we can do.
Yeah.
Questions means query are not there yet. So
Hmm.
if it is
People
there,
can raise hand and they can ask. If there's nothing, then I think
yes.
yeah, we can give some time to them for
Sir,
questions
we have
to
one more
ask.
presentation, sir. We have
Okay,
one more session, so we
okay,
can
okay,
15,
okay.
20
Please
minutes.
go ahead
We
then.
can
Please
have
go ahead.
concluding.
Yeah,
Sir, sir.
please
Yes,
go ahead.
sir.
Thank you.
Yes, sir. Thank you so much, sir, for your valuable time. Thanks to Rashmi ma'am. Thanks to Yashwant sir. Sir,
Thank
one
you. Thank you.
question is there, if you don't mind, sir.
Yeah, please.
Huh. A research scholar filing a patent, who does a patent belongs to? Means,
See, it's very tricky question. When research scholar is doing research, so he generally doing research under the guidance of a professor in the university. So then university policy will apply to that, who will own the patent in that case. But if, as I said, independent invention out of the scope of his PhD work or a research work under any government project or let's say research will also happen in two, three conditions. One is he is pursuing research based on his own identified problem along with a guide from institution, then ownership issue would be different. If research is done in extramural project of a government, so it depends on the grant condition of that particular project to that institution. So it case to case basis it will be decided.
thank you, sir. So, sir, we'll continue with Miss Kiran ma'am.
Yeah, please.
Yes, sir. Thank you, sir.
May I start? Yes, sir. Thank you, sir. Good afternoon, everyone. Thank you for the opportunity. So, my name is Kiran. I am from Technology-GUJCOST. We are a global startup company. We are based in Bangalore. We have 100 employees. We are
Yes, ma'am, you can start.
Okay.
Yes,
You can also
it,
see the
it's
PPT.
working. Yeah.
Okay. I'll be talking about two topics mainly. The first is the copyright. So what are the basics of copyright, or what is copyright actually, or what are the subject matter of copyright? Then I'll be talking about the registering procedure of the copyright. So the first thing is that what is copyright? So it is a type of intellectual property. As we all know, there are various types of intellectual properties such as patent, trademarks, designs, GI, copyright. So what is the major difference between the copyright and all other IPs? Is that the other IPs are, they are somehow related to they are actually industrial property. So somehow some industrial process are involved in all other IPs, but not in copyright. So how copyright is different from it? Copyright is basically where the works are protected, where the creativity is protected. So where there are people who have created some kind of work, they have created, uh, they have put out their thoughts and expressions and feelings onto a paper or in some other mediums that we will be discussing as the subject matter of the copyright. So mainly the copyright is giving the protection to the people who have created some kind of work. So, and it also gives some exclusive rights, some exclusive a bundle of rights to the people who are the basically the originator, or we can say author, who have created the work. So these rights could be a right of reproduction, a right of distributions. There kind some kind of disturbance, I guess.
Yes, ma'am. Rashmi, ma'am.
Kiran madam, Dr.
Yes,
Kiran Sharma madam, can you please mute if you don't mind?
just a second.
No, no. Rashmi, ma'am. Ma'am, your microphone is on the on mode. So please turn off your microphone. Rashmi, ma'am.
Shall I start?
Yes, you can start.
Okay, so there are some exclusive rights which are given to the people who have copyright protections, who have created the work. So these exclusive rights are basically where the people who have created the work, they can solely use these rights, and if other person wants to use these rights, they have to take the permission from the person who has created the work, from the author. Okay, or there are other options that the author of the work can assign it or can license it, but these are exclusively given to the creators of the copyright. These rights could be a right of reproduction, a right of distribution. There are communication rights also. Then a right to perform in public, right to make it available. These are some exclusive rights or economic rights which are given to the authors. Then it also protects the creator of the work from the unauthorized duplications. So obviously these rights are exclusively given to the people, and no other person can use it without the permission from the author. So it also protects the work from the unauthorized duplications. Then what is the objective of copyright? So there are few objectives which we can see. The first one is that it encourages the creators of the work to come up with some creative ideas. It can also encourage some other persons, not only the creators, that if they might have some creative ideas with them, they can come up with it. They can show it to the people, to the world, that they have created these good work by them. And also it protects the expressions of thoughts and feelings of the author. Then it protects the author from the unauthorized use, as I've already told that the exclusive rights are given to the author only, so that no other person can unauthorizingly use that work which is given to the author of the work. Then it also provides some incentives and rewards to the author, as for example, if a person has written down a book. So if he wants to sell his books, so he circulates his book to the like around the world, then he can earn it from royalties. Or so it also provides some kinds of economic benefit to the people. Then apart from that, it also gives the recognition to the people, that obviously you become a known person in the world, or it gives some kind of recognition to you that this particular work is created by this person. So it gives you economic benefits. Apart from that, it gives you recognition, it protects your work from unauthorized use, it protects your work. Then what is the criteria for copyright protection? So these are the three main criteria which should be there for getting the copyright protection. First is the originality. Originality is basically where your work is original. It has not been copied from any other source. So your work must not be copied. It must be your original work. It must have come out from your skill and labor. You have created your work. It must have come out from your ideas and from your expressions, and it should not be taken from any other person's work. Then the second thing, one is fixation. Fixation is basically that your work must be in tangible form. Obviously, a person cannot take a copyright protection on the idea per se, or anything which he has in his mind. He has to put that work in a tangible medium, in a fixed medium. So you have to write it down a story, or you have to record a song in any electronic medium, or you have to perform in public. So all these things must be in some kind of tangible form. That is called fixation. And the third criteria for getting the copyright protection is creativity. So for copyright, it is also one of the most important thing, that your work must be in. And there is also a doctrine of modicum creativity, which means that your work must have some kind of minimum creativity. We are not saying that you're obviously we can also say that who will decide that this work is creative or not? It solely depends upon the like judgment of a person. That is true, that is fine, but there must be some kind of minimum creativity in it. It must not be something कुछ भी नहीं बना हुआ होना चाहिए. There must be some a minimum kind of creativity in it, which a rational person can judge that yes, it is original, it has some kind of creativity in it. So these are the three criterias which you need for taking the copyright protection. Then what all are the subject matters of copyright? So Copyright Act provides a few subject matters of the scope of copyright, which I'll be telling you. The first one is the literary work. Literary work is which is written down or typed down, we can say, in a literary manner, in a literature manner. For example, we have books, we have novels, script, lyrics, poems. Then there are also like commentaries, directories, concept notes. In fact, the translations and adaptations of the literary work can also be protected. So if there is already a work which is already in existence, so if somebody wants to translate it into a different language, that person can also take a copyright protection of it. But of course, he has to mention the name of the original author while taking the copyright protection. Then the adaptations of the literary work are also protected. Adaptation here is where if a person wants to create a work, it is basically a derivative work. So if a person wants to create some another work from a already existing work, for example, if there is a story written down, if there is a book, and if somebody wants to make a movie on that story, so it is a kind of adaptation. So a literary work which is already in existence, and now you want to make a movie out of that literary work, so now then you can also file for the copyright protection for your work. And then the computer programs, tables, compilations, all these also fall under the category of literary under copyright, like Indian Copyright Act. Then the second subject matter is artistic work. Artistic is basically any kind of art which is there. For example, a painting, a drawing, photographs, posters, pictures, anything. And then it also includes some kind of creativity or any kind of craftsmanship. Any person who has created a craftsmanship, basically any work which includes any kind of craftsmanship, so that will also covered under the artistic work. The work of architecture is also included in artistic work, sculptures, engravings, moldings, even the like any companies or any government departments or any other organizations logos, labels, symbols, emblems, that also can be protected under the artistic category. Then after that we have dramatic work. Dramatic is basically where in simple language we can understand the play or a theater which is being performed in public, so a drama basically. So if there is any a piece of recitations, or if a person wants to recite his story or recite his poem in front of public, that will be covered under drama. Then the choreographic work, any kind of entertainment in a dumb show, that will also be considered as a dramatic work, or any scenic arrangements. In fact, all these works fixed fixed in a form, like in a written down form, will also be considered as a dramatic work only. Then there is musical work. Musical work here is where there is a music in a graphical notations. So one thing we have to like understand here is music is different from sound recording here. Like the sounds which are being recorded, the songs which we hear is not music here. The music is basically where there is a musical composition which is written down in a graphical notations form. Fine. So it does not include songs which are spoken by the people, which are performed with the music here. This is not this will not be considered under the category of musical. Musical category only includes the music which have like graphical notations in a written down form. Then there are cinematographic films. Cinematographic film is, in simple language we can understand, is where there is a audio recording, and with audio recording there is a video recording. So in like the movies we see, in movies we see that there is a visual which is coming in front of us there, and with that there is also audio which is coming with it. So where there is visual plus audio, it will considered under the cinematographic film. So the motion pictures where there are moving pictures, and along with it there are the audio also which we are listening to, that will be considered in cinematographic film. And in simple language, if you want to understand, the movies which are being played in the theater or being created will all fall under the category of CF. And the last category is sound recording. Sound recording is basically recording of any sound through any medium. It does not only include the songs which are being recorded. It could be any recording. It could be recording of anything. It could be a recording of lecture, for example, like what I am doing right now. If it is recorded, that it will be fall under the category of sound recording. Like recording of any songs, speeches, or anything which is being recorded on any medium, right? So that will be considered under the sound recording. So these were the like 6 major subject matter on which the copyright gives the protection. Apart from that, the thing which is like required to be understand is who all are the authors of these subject matter. So basically author are the persons who have created these work, right? So for literary or dramatic work, the author is known as author only. For musical work, the person who has created the music, the person will be the music composer. So the author basically who will be known in the copyright law is music composer for music. Then for artistic work, the author is artist. For photograph, the person who is taking the photograph. For cinematographic film and for sound recording, the author is producer. And for work which are being computer generated, the person who has causes that work to be created. So the person who has created the computer program or anything which has been computerly generated, that person will be the author. So all these people are the author for the works that has been created by them. Then what is the term of protection? If we say that it is a original literary, dramatic, musical, or artistic work. So for these four categories, the term of protection is 60 years from the death of the author. So a person who has created the work, he has the copyright protection till he is alive, and after his death, he even after his death he have 60 more years which by which his work is protected. After that, the works comes under the public domain, and in the category of cinematographic film and sound recording, from the date of the publication, so from the date on which it is first published in the sense that like on the first day on which it has been publicly performed in or publicly shown to the public, publicly like shown to the public, like any movie which is shown to the public for the first time, that will be the first date of publication. And after that, 60 years, these are the term of protections. For original literary, dramatic, musical, and artistic work, the term is 60 years after the death of the author. And in cinematographic film and sound recording, the term is 60 years from the date of the first publications. And then uh, here the thing is, now the second part of the uh, my presentation, which is the registration process of the copyright. So first the question arises is whether the registration of the copyright is mandatory. So the answer here is no. Once a person has created a work, he automatically gets the copyright in his work. He will be known as the author of the work. He has all those rights which I have talked about, and he have the copyright in his work from the very first time he has created his work, and there is no need to take the registration. Registration is not mandatory, registration is not compulsory, but registration, it is always advisable to take the registration because the certificate will be considered as your prima facie evidence in the court of law. So if suppose you have created a work and you haven't taken the copyright protection over it, and in future somebody tries to infringe your work and he copies your work, now there will be nothing to prove that who is the original author of the work or who has created it prior to the other person. So that certificate will give you will be considered as an evidence in the court of law, which will prove that this work was firstly created by you only. So acquisition of copyright is automatic. There is no need to take the copyright protection, but it is always advisable to take the copyright protection because it will help you against the infringement of your work. But as I have said that the registration is necessary, so I would like it is not necessary, but it is advisable to take it. So now I would like to tell you the registration process. So there are you have two options to register your work. First is the e-filing and the second one is physical filing. For e-filing, what you can do is you can go on the website of the Copyright Office, and then there is the option of e-filing. You can go there, you can create your login ID password, and after that you can fill a form, which is a form 14. And in physical filing also, you can go on the website of the Copyright Office, you can download form 14 from there, you can fill it up and can send to the by hand or by registry, speed post, anything, to the Copyright Office, and with your documents and 2 copies of these form and documents. So you can either e-file it or you can physical file it. After the Copyright Office receives your applications, a diary number is issued to you, to the applicant. After the diary number is issued, there is a mandatory 30 days objection period. So what happens in this objection period is, if any person has some kind of objection related to the work which you have given for the copyright protection, then those objections will be heard by the registrar of the copyright. So the letters will be sent to the parties who like both the parties who have applied for it and the party who have objection of it, and then it will be heard by the registrar of copyright. Then it will be decided whether the work will get rejected or will be accepted. The application will be accepted. If the objection fails, then the application will be accepted, otherwise it will be rejected. So, and if there is no objection, so after the 1 month period, the application will come for the scrutinization part. So your application will be scrutinized by the examiners. While scrutinizing, all the documents will be checked and it will be seen whether there is any kind of discrepancy in it or not. So if there is discrepancy, then a discrepancy will be raised, and if there is no discrepancy, then it will be sent to the approval. And both these things are approved by the deputy registrar. So after the scrutinization, your application will be sent to the deputy registrar, and he will approve that whether the application has some kind of discrepancy or not, or whether it should be approved. So if there is discrepancy, then a discrepancy letter will be sent to the applicant, and he has to like overcome those discrepancies. And if there is no discrepancy, then it will be sent for the approval. So the procedure in our office is that we send two discrepancy letters, and after that the case will be sent for the hearing. And if there is no discrepancy, then it will be approved, and it will be the application is approved, and the registration certificate will be given to the applicant. And if there is no if if it goes in the hearing process, and after the hearing it will be decided whether the application will be rejected or not. If it is rejected, it will be rejected. But like if the person has not overcome with the discrepancies, and if it is approved, then it will again be go for the registration process, and the extracts of the registrations or the certificate will be sent to the applicant. And there are all these categories in our copyright office. So we have all these categories which I have already told. There is literary category, there is artistic category, there is CF categories, SR category, and music category. But we also have one more category, that is software category. In law, the software is covered under literary work, but for making the process more easier, we have put the software category in a we have make a one more category of it. So these all were the categories, and all the whatever kind of work you have, if it falls under the category of literary, then you will file in it, and so on. And there are also different fees for all these categories, and all these things will the registration process, the work manuals, all these things are already available on the copyright office. So if there is any kind of confusion, one can go and check on it. So these were the main things which I have to talk about. So thank you very much.
Thank you, Kiran ma'am. During your session, we have lots of questions, but I think it's
Okay.
already done by Yashwant sir.
Okay.
So thank you again for your very nice informations about the copyright. And I would like to thanks to our speakers, Mr. Yashwant sir, Rashmi ma'am, and Kiran ma'am, for the wonderful sessions. And also to our participant. In the whole day, whole 6 days, I was always trying to say, please turn off your cameras. And so we are now ready to take a group photo. So dear participant, please turn on your cameras so we can take one picture. Kiran ma'am, you can just stop presenting, so it will be like we can take a whole picture. Dear participant, please turn on your camera.
Sahu sir, will you be joining by switching on your camera?
Yes, yes. I think we have taken so many photographs. So during the six days, we have seen a lot of informations about the IP, patents, copyrights, MSME schemes, trademarks, etc. Also, we have seen GI also. So I hope it will boost your knowledge regarding IP. So we can conclude with one line that IP is the fuel that powers the engine of prosperity and fostering inventions and innovation. So I would like to thank to Sahu sir for always anchoring us and always push up for to do the new things and innovative things. And I would like to thank our colleague Miss Satya ma'am and Vimal for all the coordinations. Without the team, it can't happen. Whole 6 days, it was very nice session, and we have cleared all the doubts regarding IP. So thanks to our speakers, today's speakers, Kiran ma'am, Rashmi ma'am, Yashwant sir. Thank you so much, sir.
Thank you very much.
I think Sahu sir is there.
Once again, I would really like to thank our
Yes, sir.
State Scientific Council advisor and head, Dr. Devapriya Datta, for his kind support and guidance for all State Scientific Council to work for the common cause. I would like to thank our Secretary, Harit Shukla, Department of Science and Technology, Government of Gujarat, for his kind support, encouragement, for promotion and popularization of science technology, as well as the IPR. I would like to thank all our guest faculties, speakers for all these 6 days program, for their very insight and in-depth discussion. And I think today Dr. Rashmi Sharma Madam has given also a good way forward, how the State Scientific Council to fill the gap between our expectation, our demand, and our the current state of the activities, so that we can come to the expectations and we can be the part of this Atmanirbhar Bharat. And I think we have the faculties like Yashwant Dev Panwar and all other faculties in other sessions also, from the patent, GI, trademark, and we have a very good system of patent attorney panels also here in Gujarat, in GUJCOST. So we'll be looking forward that whatever the issues, whatever the problem statements are there, in terms of patent, in terms of design, in terms of trademark or copyright also, so and GI also, together we can take it to the respective patent filing offices at design patent or design or trademark of whatever the case may be. So this type of webinar will be signifies our understanding about the issues, and also to stimulating our effort that yes, we can do it. These are the issues to be taken care of. So I once again thanks to all our faculty, all our department, all our university department, IP schools also. And I think the 6 days we have a lot of discussion. So let us together we can work, and we have to match the fill the gap. So with this word, I once again thank to our department, our colleagues also in GUJCOST, PIC staff, So you people are working very hard for coordinating the students as well as the faculties and the department also. Thank you so much. And we will definitely will have a change maker. So with this word, I once again thanks you, and we can start our journey from right now. Thank you.
Yes, sir. Thank you, sir, for your kind words. Without your support and encouragement, it can't happen, sir. So we are very much happy for doing this 6 days IP festival, and I'm sure we'll come up with more webinar from the next month. So please stay connected to our website and Twitter. So we will be there for you. Any query is there, please drop your query in the info.pic.gujcost. We will happy to receive your all the queries. Thank you. Thanks for connecting us. Thank you, sir.
Thank you, Dr. Sahu.
Thank you,
Thank you
madam.
very much.
Thank you. Thank you.
Thank you all. Thank you
Thank
all.
you. Thank you.